An Australian class action over a deadly coronavirus outbreak on board the Ruby Princess cruise ship cannot include passengers from the United States, an appeal court has found. In a majority decision on Friday, the federal court ruled the claim by Patrick Ho, one of 696 passengers whose contracts were deemed to be subject to U.S. terms and conditions, be stayed. Chief Justice James Allsop and Justice Sarah Derrington, with Justice Stephen Rares dissenting, allow the appeal by Carnival plc, the time charterer of the vessel, and Princess Cruise Lines Limited, the owner and operator of the vessel. Read more. Albanese puts foot down on controversial tax. They had challenged a judge's 2021 decision rejecting a preliminary application to stop a subgroup of overseas passengers from being part of the action. Many passengers contracted coronavirus and 28 died after the outbreak on the Ruby Princess, which left Sydney on March 8 and returned on March 19, 2020 after sailing via a number of ports in New Zealand. Susan Carpick commenced representative proceedings against Carnival and Princess, with the group being made up of passengers, executors and close family. She alleges the respondents negligently and in breach of their duties of care allowed the voyage to proceed and failed to take adequate measures to protect passengers from the risk of COVID-19. Read more. How Australia could become global energy superpower. They also allegedly failed to warn passengers of the risk of contracting the disease. Further, they allegedly engaged in misleading or deceptive conduct and breached their consumer guarantees under the Australian consumer law. Of the 2,651 paying passengers on board, the respondents alleged that 696 contracted their cruise on U.S. terms and conditions and 159 contracted on U.K. terms and conditions. The balance are said to have contracted on Australian terms and conditions. The differing conditions include a class action waiver clause in the U.S. terms. Read more. Taiwan shoots down drone off Chinese coast. Justice Angus Stewart had ruled it wasn't necessary or appropriate at this early stage of the proceedings to determine the law applicable to the U.S. and U.K. subgroups' negligence claims. He noted a stay on the U.S. passengers would result in the fracturing of the litigation, with essentially identical claims being brought in the federal court and any state claims being brought in the U.S. But the appeal court ruled that the terms of carriage between Carnival/Princess and Ho were governed by the U.S. terms and conditions incorporating the exclusive jurisdiction clause and the class action waiver. It concluded those clauses ought to be given effect and Ho's claim should be stayed. The court ordered the matter be remitted to Justice Stewart for determination of the extent to which its reasons affect the claims of other members of the class action.